Number 64, People v. King.
Good afternoon, Your Honors. Brad Osler on behalf of the people. The rule I think that this court should come down with in this case, there could be a couple variations, but it could be as simple as this. The amended Section 3030, subsection 5 of the CPL should not be applied to cases that were commenced and were trial ready, where the people declared readiness for trial prior to January 1st, 2020.
Those are both necessary conditions, commenced and trial ready?
I think that is a rule that would make sense. I think I would say you could also.
I was just trying to clear up your articulation.
Absolutely.
I was trying to make sure you weren't saying if it's commenced, that's enough, or if it's trial ready, that's enough.
I think it could be either one. However, if the court wanted to narrow it down as much as we could, I think it would be consistent with the reading of the statute and all the ways in which we interpret
And by trial ready, there would have been a statement of readiness made either on the record or off record.
Correct. And I say that because I think this is sort of the main crux of my argument, is that when the people declared ready for trial, in this case in April of 2019, that's a legal status. It's effectively a legal document, and it could be obviously an oral statement on the record, but it's a legal status that the people set forth. And to apply the amended 3030 and its connection to 245 to effectively nullify that.
No, it doesn't nullify it. It's just imposing requirements starting Jan 1. It doesn't nullify the fact that you declared ready and you were in that ready status at that time. Just saying, now you've got these requirements, satisfy those requirements to continue your readiness status.
Except that's not exactly what the statute said. The statute says to declare ready, you must, follow 245, et cetera.
Under the new regime.
Under the new regime.
Correct.
But when the people declared ready, there was no.
The prior regime, you were ready.
Right. The statute did not say that as of January 1st, prior statements would be invalidated.
Counsel, you're not saying that the additional discovery obligations effective Jan 1 wouldn't apply to your case. That's not how I take your argument.
I don't think, I would say that I don't think they were to apply to this case. And part of the reason I would say that is because if we looked at the timelines laid out in 245, at that time, 15 days to comply, and then the defense getting a reciprocal 30 days to comply, with our January 27th.
It seems to me if you uncouple the discovery obligations from the 3030 penalty or link, which we said was the radical new thing in Glendale, you're not upsetting any status. You're just saying you have to provide them with this material before you go to trial. You haven't gone to trial yet. Why don't you have an obligation to provide them with that?
So in that way, I would agree that people could be said to be obligated to provide that, as long as, of course, though, that did not invalidate their prior statement of readiness. In this case, the items that we hadn't turned over were the grand jury minutes, which there was no obligation to before 245.
So are you arguing that the status of being ready should have stayed in place, but if the law changed and they asked for those things, are you saying you weren't obligated, or you should be given an opportunity to then satisfy the next part?
I think it would be fair to permit the people an opportunity to satisfy, as we attempted to do here.
And the reading here, did that allow for an opportunity to then satisfy as of the effective date?
Well, the trial court in this instance, I don't know if it's exactly clear, but I would say that it essentially did not apply 245, or at least the connection to speedy trial. The court said, please provide the grand jury minutes and the electronic discovery that we also provided. But the court rejected any sort of challenge to our prior statement of readiness.
I'm a little confused. Did you ask for more time? Did you say that there are extraordinary circumstances, or the reason that we need more time so that we don't suffer the consequences under the new regime?
We did not, but I don't know that we needed to, because we
Well, that's what I want to clarify, if I can. I'm not sure I understand your position. Is it that the 245 requirements applied to you but you should have been given more time, and if you didn't comply within whatever that window would then have been, that then you could have had your case dismissed? Or are you arguing that 245 applied, but not the sanction of dismissal under 3030?
I think the latter would be the more fair and consistent
And why is that
interpretation.
consistent with the language of the statute, that latter interpretation?
Because the statute is of such magnitude or breadth in terms of the demands upon one
So-
party here.
I mean, that for me raises a question I'm not sure I understood about the legal framework that we should apply here. So you cite Berkowitz, and you argue that to apply 3030 would make the prior statement of readiness a nullity, I think. And your adversary relies on Landgraf, which distinguishes between substantive and procedural rights. So what's the interplay between those two legal frameworks, and how should we sort that out?
I think my interpretation of Landgraf or Berkowitz or any of the other cases that talk about retroactivity and what makes a case, or excuse me, what makes a change in the law not so procedural and more substantive, all of those would support the idea here that this statute, this change, is much more than a simple procedural change. And I say that in light of...
They're simple or procedural? Do we need to decide if it's substantive or procedural, or is it the nature of the impact that you're relying on?
Well, I think the nature of the impact is an important part of how this court would determine that. And I say that because the instances in the case law that we have where something was held to be purely procedural, and I'll cite very quickly Clayton v. Clement, which just amended the type of hearing that would be held at the end of a particular petition. That's not something that affected any right of any party. It's not something that affected a party's ability to go forward or actually prosecute their case in this instance. The application of the amended 3030 and to that end the connection to 245, resulting in effectively a dismissal now 27 days into January after the law went into effect, where the people had declared ready for the previous 8 or 9 months, that's not a procedural change. It just can't be said.
But can it also be that we can look at this as pure statutory interpretation, and we only get to Landgraf and retroactivity if we perceive or read this statute as saying the people's readiness is undone?
I would agree with that as well. And we have here a just flat-out indisputable silence from the legislature as to whether this would apply to a case in the stance that our case had at that point in time.
So because you had announced ready, there's nothing in the statute to suggest, because it says 245 says, I believe, 50, the prosecution shall not be deemed ready. Your position is, I take it, you were already ready, so you don't have to be deemed ready.
Correct.
And is
Could you
that
have-
your distinction between those cases where, coming into January 1, where you've announced ready versus the cases that were in an unreadiness state?
Right. I think that's a distinction. If we had not declared ready, I don't think I could stand here and say, well, you can't really
But you
apply the law.
Could you have fallen out of readiness?
Could
you have
a case...
ended up unready without, forget the amendment for one moment. Doesn't that happen?
It does, but I
What's the
think...
difference here? The legislature passes requirements and says you must satisfy these requirements, including the certificate, in order to be deemed ready. Moving forward as of January 1st.
Sure. A case prior to that date, for a case to be deemed unready or having the people's statement be deemed illusory, as we would term it, there would have to be some sort of finding of some
Or
sort
if
of...
you came in the day of trial and said, we can't proceed, Your Honor, we're not ready.
If there was a factual circumstance that
Yeah.
supported an
Yes.
idea that we had...
So it is possible,
Sure,
even
sure.
after declaring readiness, that you're no longer ready at a future time.
Yes, that is possible. It did happen
Yeah,
when
I
there was
understand.
some...
I'm sorry, did you say it did happen or it didn't happen?
Not in this case, but I mean, it could have happened.
Did it happen in this case? Was there ever a time when the people came in and said, or especially after January 1st, and said, we're not ready?
No.
So, sorry, go ahead. No, it's okay.
We're not ready as a matter of law. Because you didn't turn over the grand jury minutes.
Well, that's what
And you
the,
didn't ask for more time.
I mean, the Fourth Department, I think, is effectively saying you failed to declare ready at any point in time in the month of January, and therefore those 27 days are.
Or otherwise act within what would have been appropriate under the law to seek an extension or an opportunity to respond, or to be somehow not burdened, let me put it that way, with
Correct,
the
and-
obligations without the risk of the 30/30.
Right, and we did not do that, but that, again, my rebuttal to that is simply that we were ready, and that I think it is effectively a retroactive application to undo something that, a status that we previously had.
But there was no date on which you came in after having declared ready and said, today we are unready because a witness is unavailable or the prosecutor, is in another courtroom or something like that. Is that correct?
Yes.
Were there items of discovery required by the new law that you hadn't produced as of January 1st?
My reading of it, I believe, would just be the grand jury minutes that would not have otherwise been discoverable.
When did you disclose those?
So those were turned over, I believe it was on January 17th, 10 days prior to trial. And the ultimate challenge by the defense was brought up shortly before trial, and then the argument continued on the first date of trial.
So the 9/11 tape, just to clarify, that had been turned over?
The grand jury minutes?
The 9/11 tape?
Oh, I'm sorry. I believe the 911 call was not, but it would have not been attainable by the by the start of January 2020, because they're simply not retained beyond a short period of time, given that the case was in September of 2018.
Oh, but I thought pre-Gen 1, the prosecutor's representation was that indeed these were within the control of the people and would be turned over at the first practicable, an appropriate time. I'm
So
trying to
we
remember
had
the exact quote, practicable moment.
We had certain information in our file. There were photographs, I believe some other electronic evidence. There was, I believe, perhaps a recorded interview of the defendant. So those were in our file and were offered to be viewed at any point in time. I guess I don't want to promise without reviewing the record whether or not 911 was included, but that wasn't really, the bulk of the argument anyway at the time of trial.
So are you arguing that upon the effective date of the new obligations, there was no opportunity given for the people to be in compliance with the additional requirements?
Well, I think there's certainly there was practically speaking, an opportunity. There were 27 days, I suppose, where the people could have submitted a certificate of compliance. But my position would be that it was not necessary, given our previous readiness.
It's a little more than that, isn't it? Because there was also a period between when the statute was enacted and when it became effective, so.
Except that lead-in time does not suggest that the people were expected to, going forward, comply with that.
It might suggest they could have.
It could suggest that they could have.
Might have been a prudent course, you wouldn't be here.
Well, that's certainly true, except that then goes against how we typically interpret statutes and whether they're going to apply prospectively or
It's a
retroactively.
high-risk venture.
Did your
You
office
could have
file other
accounted-
COCs in regard to other cases prior to January 1st or on January 1st? What was the policy?
Guess I don't necessarily know what the practice of individual ADAs were.
Is there a policy for the office that you're aware of?
Not on the record here, in any event.
Yeah.
I mean, I think as you just mentioned, Justice Rivera, or Judge Rivera, it would be the prudent course of action to attempt to comply. But therein runs, and I don't want to strongly rely on this, but therein we run into a real practical problem of how on earth do you do this on all the pending cases, all the newly arrested cases going forward. It's really not possible.
Clarify, because you said something, and I thought, I may have misread the record, so please help me here. I thought that the prosecutor had indeed tried to serve the certificate, and defense counsel refused to accept it.
Correct, he did.
I don't know how you do that, but okay.
Well, and that's where I think, in we're in the first 4 weeks of January, there's obviously no court guidance, and there's going to be differing opinions on whether the people did or could comply, or how we go about doing that. So yes, the defense attorney at trial stated that he rejected it. I'm not really sure what effect that has. I'm also not sure that it really impacts the decision here, because the trial court didn't really, it essentially didn't hold that the people needed to or
Well, it is an
filed a
example of
bill.
an effort to comply with the statute.
Sure, it was. But, it was not considered strongly in the moment, I don't think.
And then part of the problem here was the fact that even before the people declared ready initially, they had used up so much of their speedy trial time.
Correct. And as we just discussed a moment ago in terms of the amount of time that we could use for planning, well, while I will admit, probably not advisable to use 175 days of your speedy trial time before you indict a case and declare ready, that was not really a risk in April of 2019, the way it might be now, where there are,
But it still was pretty risky to eat up as much time that was taken up here, although the complexity of the nature of the offense was such that sometimes you can't proceed as expeditiously as you would want.
Yes, but it would also be, I think, fair to say, quite unwise to use the bulk of your 6 months now, where you have very onerous discovery obligations, including grand jury minutes, which you won't have until you actually indict the case.
And was compliance impacted by having resources available to go through the files, to get the information, to turn it over?
There's a practical aspect of the hours it takes for the staff in our office to actually go through each file, upload it as we do now, disclose it digitally. We were also limited on the number of grand jury stenographers that we had by statute, which was then amended because I'm not sure, frankly, many of us were aware of that fact, but suddenly we had these time limits to comply with, and the number that we were legally permitted was just flatly insufficient. So there were a lot of aspects to this law that not only were impossible to foresee in early 2019, but I think applying them in 2020, months and months later, where we had declared ready and were validly relying on that for a long period of time, that makes it quite unjust, I would say. It consistent with the way we interpret laws in terms of what makes them retroactive or prospective. I think application of this regime and really the speedy trial connection, this would be a retroactive application, which, absent any indication on the record or from the legislature, I don't think is appropriate here.
Thank you.
Thanks.
Good afternoon, Your Honors. May it please the Court, Philip Rothschild from the Frank H. Hiscock Legal Aid Society on behalf of Respondent Alvin King.
Counsel, how is it that this wasn't a retroactive application here?
Well, first of all, it had no effect on any prior announcements. Those were still valid, as Judge Rivera pointed out. It only prospectively applied as of January 1st. In Majewski, this court said, while retroactivity is generally disfavored, statutes governing procedural matters.
So as of January 1st,
Yes.
there were new obligations that the people had that they did not have earlier. Is that correct?
Yes, and they had.
And how were they given an opportunity? Were demands made, or were they just supposed to sua sponte, deliver up these new things in order to be ready?
Well, under the statute, they were required to disclose all these items under 245.
As of midnight?
As of January 1st. Well, I mean, as of the applicable
Yes,
time period, of which they had 9 months of lead time.
Yeah,
They
but in
had-
Galindo, we said the lead time spoke more to prospectiveness than retroactivity, right?
True, but I believe that the legislature makes the laws.
Correct,
people
and the
follow
legislature
laws.
here said, in order to be deemed ready. It didn't say from this point forward, the only way to be ready, or all prior readiness statements are null and void until X, Y, and Z. I mean, it said deemed ready, and the people were ready. Like, where can you point to me, forget retroactivity for a minute, where can you point to any language that suggests, either in 245 or 3030, that the legislature meant to undo readiness?
I would submit that under 245-50 subdivision 3, because we look at the language of the statute when we're interpreting them.
Right.
That's the first thing we look at. The legislature said, notwithstanding any other provision of any other law, absent any individualized finding of special circumstances, the people shall not be deemed ready for trial until they have provided both discovery and a proper certificate.
But the problem with that language is if the people have already announced ready prior to the effective date of the statute, technically, they're not asking any court to deem them ready for trial because they've already announced ready.
For the prior ones, correct, but the use of the term notwithstanding, as this court recently said in Aaron Manor, means superseding any inconsistent provisions of state law. The legislature didn't hide this. They made it quite clear. They wanted, and it wasn't put in that section by mistake. And by the way, they didn't put it anywhere else in this whole comprehensive statutory scheme. They said notwithstanding, and what they meant by that was, look, we have this big stick here. If you don't comply with this discovery.
So are you saying that that effectively says that even if they were ready prior to January 1st of the effective date of the new statute, they were no longer ready?
Yes, and that's what the fourth.
Counsel, I want to just ask you about the big stick. We said in Bay that this is an incentive, and it certainly is, right? It's an incentive to comply. And the idea was the government is, the people are taking their time producing this material and then declaring ready and that. So we're going to clarify that. And if you step back and you look at the mechanism, which was, we've described quite new, that you were tying the 245, the new discovery obligations, to a 3035 provision. I don't see how that fits with, on January 1, the people have done what they needed to do up to that point. They've declared ready months and months before. There's 1 day left on the clock. January 1 comes, they have 1 day, 12 hours to provide you with all the new discovery. How is that an incentive?
Well, because of the comprehensive statutory scheme. It's not like you had this, they also had opportunities under 245-70 for additional time. They had opportunities under 245-50 subdivision 3 to make an individualized statement saying, hey, this
No, but I'm
items
just
are
thinking
lost
when
or
I
destroyed.
step back and I look at the way the legislature structured this and what they were trying to do with this very new incentive stick, why would it ever apply as of January 1 to a case where they have been ready for 9 months and they have 1 day left on the clock?
Because they've redefined readiness, because this is what the legislature wanted. They wanted to make sure that everyone was on the same page regarding this, and that no one would be
But
deprived of this
that's
discovery.
your result. But what in this statute tells me that that was the intent? That on January 1, if I had 1 day left on the speedy trial clock, I am now unready. I was ready, I've been ready for 9 months, I've been ready to go, but on January 1, I'm not ready, and now I need the incentive of having the case dismissed under 3030, which the new provision says, when I declare readiness, I have to have done this. I already declared readiness. Now I have to re-declare readiness with this obligation, and I have 12 hours to do it.
Well, under that situation, you can move under 245-50 subdivision 3 for more time, or you can ask for the court to say, hey, we want to.
No, I don't think Judge Garcia is asking about how a prosecutor in that position might mitigate the demands in a very short period. If I'm understanding him correctly, he'll correct me if I'm wrong. I think his question is, if the legislature is intending to incentivize prosecutors, but they have this, in this case, prosecutor already, right, has announced readiness, ready to go to trial, where is the incentive to apply this law to those cases?
The incentive is, if they don't, they get their case.
No, but they've already declared readiness. That's his point.
So-
What's the incentive to get to readiness? I thought you were going to say, because the law is not only about readiness, it's
Right.
about discovery. And that's
Absolutely.
what you're trying to get.
Can't
So
you
I'm
have
just
the
trying to understand what
discovery
you're saying.
obligations without the incentive? I mean, you still have remedies for failure to produce discovery, which I think include dismissing the case. So you have these new discovery obligations, but under your view, if I don't ask for more time on January 1, right, or let's say January 2, if I don't ask for more time and I come in the next day, I'm done, because clocks run.
Well, I mean, as far as the first 15 days, I believe the Fourth Department said, okay, we're
Yeah,
going
but
to.
they made that up.
Well,
I
I
mean,
mean-
that's nowhere in the statute. They made that up.
But-
That's 15 days from arraignment or something. We'd have to judicially make up a 15-day grace period for
So
that.
I start off by saying the legislature makes the laws, the people follow them. Interpretation, that's open to debate. The wisdom of the law is not. What they're claiming here is this was too much, this was absolutely too much for the people to have to comply with.
No, I'm
to try-
assuming it's wise. I'm sorry.
To try to come at this a little bit differently, doesn't your argument about incentives have a whole lot more force with respect to cases that are commenced but where there is no statement of readiness that has been filed? In other words, that's the window in which I think those incentives, in any case going forward, would have particular application and, in the legislature's view, importance.
So if we look at, if we look at the purpose of the old law, the reliance, or the purpose of the new law, the reliance upon the old law and the effect upon the impact upon the administration of justice, in this case, the legislature made it quite clear, this is going to apply as of January 1st. And they specifically and deliberately linked it to 3030 because they said, look, they use this notwithstanding, language. And that's very powerful.
Right, but
language.
how does that not connect back to the people's rights pre-January 1, right? Because now they're saying, look, we're now tying this to your readiness, which was never the case. So suppose there's a case that the people had prior to January 1. There's a police officer who retires, he goes to Florida. The people make a decision, we can't find him, we're not going to Florida, we're not getting sheriffs there to get us his memo book. They wouldn't have needed that, right, unless that person was testifying. Now suddenly, come January 1, that would be discoverable. So what might have been before, a preclusion of that witness, some kind of instruction to the jury, an adverse inference charge, now suddenly becomes a dismissal of your indictment. How does that not impact your status and your rights pre-January 1, 2020? That's what I can't get. I hear what you're saying, it's sort of moving forward, you have discovery rights, but the penalty brings you right back to the decisions that you were making all along during the pendency of this case.
Two things regarding that. First of all, I think that the people are conflating, they're calling it the right to readiness. It's actually a continuing obligation for readiness, and that obligation, as Judge Rivera pointed out, continues even after they've announced ready. And they could be made unready by any number of things. In this case, the
So
legislature.
then, do you agree that their legal status was, as he said, nullified by the
No.
change of the statute?
No, that prior announcement was still valid, but going forward, 9 months forward in this case, they have an opportunity, an obligation to comply with this. They had ample notice of this.
And you dispute that the application does in fact cause that status to be nullified because now the people are unready, because they're required to give up what they weren't supposed to before. They declared ready.
But that readiness is dependent, as I said, it could be changed by any number of things, and in this case, the legislature made the
Right.
conscious
It's
decision.
different, though, from the old law where illusory, you declared ready, but you weren't really ready in the first place. The difficulty that I'm having in this particular instance is the people followed the law as it existed up until the date that it changed. And then the question is, what's the effect going forward? The effect going forward here is you're no longer ready. Even though the statute doesn't say we're going to take away your readiness, it says you can't declare ready until you provide these things. But the effect here, what did that? It took away their status.
To an extent, yes, but in continuation of my earlier answer to Judge Singas, there's available remedies under the comprehensive statutory scheme. In that situation, they wouldn't necessarily have to dismiss this because they wouldn't necessarily knock out the statement of readiness. Where you have the sheriff who went down to Florida, they could always ask the court, say, hey, we're asking for basically an exception from this under 240.
So is that opportunity available here for them to take those steps to not be unready?
Absolutely, these were available, and there's no indication on the record that they even attempted to do this.
But for them to take advantage of those opportunities, they would have to share in your view that their ready status changed on January 1st. Because, you know, you don't go to court and ask for relief if you still think you're ready, only to find out later that you weren't.
Well, I think it's the legislature's view. I don't think it's my view. Because the legislature specifically
Well, no,
tied.
Can I
It's-
just try to
it's-
find out? Go ahead.
No, I was just going to say, it's your reading of the statute. I mean, unless I'm missing some very clear language where the legislature said, if you're not in compliance on the effective date of this statute,
You shall not be
you are
deemed
not
ready for
ready,
trial.
even if you previously declared readiness.
Well-
I don't see that.
In terms of statutory interpretation, appellant says, well, this is bad drafting. I think that, first of all, they say that they should have specifically listed the cases included as those cases already pending. First of all, that language is superfluous. Second of all, that introduces the risk of inclusio unius, which means when you start listing people, you may inadvertently omit others. And I think if they wanted to say these people are specifically accepted, they knew how to do it.
I just want to try and walk through, so I understand what happened, what your position is, what happened with readiness. So December 31st, 11:59 PM, people are ready.
Yes.
Okay. Clock switches over. We're now on January 1st. Are they now unready?
Yes.
And that's true even if they have previously produced all of the discovery that's required by the new legislation.
Here, okay, in this case, here they didn't. They clearly, it was beyond
I'm
what.
asking you a question that
Yes.
is maybe not true here, but I want to know your answer so I understand what your view is about readiness.
Yes.
They've produced everything under the sun that's required in new legislation. The clock switches over. They are now ready or unready?
If they have not filed a certificate
Right,
of
they've not
compliance,
filed a certificate of
They're
compliance.
not ready.
They're not ready.
Pure and they're
Okay.
not ready because that's what the statute says. If they want to have an exception from that, they certainly were capable of doing so. I assume they read the statute. I assume they knew that of the remedies and rights available to them. They didn't take advantage of them. And as far as retroactivity, you know, I believe this is, no new substantive right was created here. This case is clearly distinguishable from Galindo. In Galindo, they had no idea because those people weren't even subject to, didn't even have speedy trial rights, those traffic infraction people. Here, this case was not on appeal. This
Was there an
case pending.
8-month time lag, though, for Galindo, too? Was
Yeah.
there?
There
So
was
why
a-
didn't they have notice? They should have done it in an amount of time, under your theory.
Well, I think under Galindo, I believe that, you know, that the law had been the same way for 40 years or so.
So the 8 months didn't matter because it was there for 40 years?
And here, the 8 or 9 months, I think the intent of it was basically to give the prosecution the opportunity just to get up to speed with this. And they, getting back to what I originally said, was, you know, the appellant is saying, oh, this is too much, this is unworkable.
Well, I guess that's a question of what it was they were trying to get, given time to get up to speed for, because I assume that just complying with the new discovery requirements in a timely manner on a prospective basis would require changes to the offices, ramping up personnel, all sorts of things like that. So they were given more time for something, but it's not clear to me, unless you have something you can point to in the legislative history, what that something was.
I think it was given time to comply with the statute.
But what, well, that begs the question.
I-
That doesn't,
Well, I don't know what specifically
Yeah.
it was. I mean, they're talking about having to get more court reporters or things of that nature, but they were on notice of it. They knew this was coming down the pike, yet they failed to act.
Do you have a sense, you may not, no, it's not in the record, but do you have a sense, given the practice, I'll ask that also to the prosecutor, do you have a sense of how many offices took the same position, that it was not going to apply to them until a case was filed after January 1st?
I do not, Your Honor. One more thing, as far as the items that were missing, I would ask this court to look at I think it's page 73 of defense counsel's motion made on the day of trial. It's more than just the grand jury minutes. It's a number of things, recordings, other items which were just not provided. And some of the items.
But again, those items were the items that were required after the effective date of the statute to be turned over, correct?
Yes.
Thank you.
And included among them, I believe, was, losing track here, but these items included matters which were just absolutely, they turned them over to the judge instead. And they said, well, that's sufficient, have the judge review it, and that doesn't comply with the law. The
Well, then
legislature-
why, unless you take a different position, why were they trying to serve a certificate?
Well, they did that after the speedy trial motion was made. And they figured, well, we can maybe get in here late, and, you know, by
Yeah, but
that
the
time, they were already.
certificate is a representation that they're in compliance.
Well, I believe it shows that they were trying to be in compliance, but I think that they just missed the dates. Thank you. If there's nothing further, we would ask that the lower court decision be affirmed.
Thank you.
Your Honors, I don't really have anything to add other than to note that I think two quick points. The Fourth Department dissenting justice pointed to the idea that the people were reverted to a state of unreadiness, and that's the issue I think I have with the majority's interpretation.
Yeah, but the problem is
below.
that's not accurate. At least I don't see it that way. The regime in place that you declared readiness under is no longer in place. That remains. No one was saying that you weren't ready under the old regime. There's now a new regime, and you've got to comply with the requirements of that regime.
Right, but I think, I mean.
Readiness has a different, all I'm suggesting is, readiness has a different meaning come Jan 1.
I
right?
certainly understand, and I would agree with that, except to the extent that, as I think we've been bouncing back
It
and forth on.
can't be you're unready because it's not the same regime. That's the point.
But
It's a different
that's-
regime.
That is what I would say has happened, though, is that that interpretation has forced the people into a state of unreadiness, which,
Was force the people to comply with the law, and if they needed more time, they could have sought to get more time, but they did not. But can you try and answer my other question? Do you know sort of how many offices took this same position
I
in terms
don't.
of their statutory
I
interpretation?
don't, I couldn't.
That's fair.
Counsel, I
Thank
do
you.
see cases with the same remedy, the same incentive being applied in Queens and Manhattan.
There has been, I believe, a mix of lower court authority in terms of whether this would be applied, as I would say, retroactively, or at least in terms of finding the people
I
unready.
mean, I
as
think
of
the fact
January
that they
1st.
were considering cases in Queens and the New York DA, the Manhattan DAs, and dismissing indictments seems to indicate that at least some of the prosecutors in those offices weren't filing certificates.
Oh, I mean, I would assume, because otherwise there wouldn't be dismissals, sort of shortly after January 1st. The only other brief thing I would like to mention is with respect to that notwithstanding language. I think it would be more reasonable to see that word inserted sort of in the middle of a paragraph, kind of buried in the statute, in terms of how we analyze the people's readiness, in as much as it seems accepted now, we look at 24550 first, as in have the people actually complied, filed a valid certificate of compliance. And then if so, then we move to 24580, where we would look at if there's any prejudice to the defense for any sort of delayed disclosure or something like that, whether there would be a remedy. I think that notwithstanding might signal that sort of two-step process. I don't think it's fair to say that the insertion of that one word there is meant to signify the application of the whole new regime and the tie to speedy trial to all those cases that had been declared ready prior to that.
Is it your position that without the mandatory consequences, if you're not in compliance and you're not ready within the timeframes under the new regime that then requires the dismissal if you've gone over your timeframe, that a court nevertheless would have had the discretion to dismiss?
If we had not declared ready, I think I don't think I could come up here and make the same arguments as I am. Because if we're declaring ready in January, we have to comply with the law in
No, I
effect
get
at
that, but
point.
let me try it a different way. Let's decouple the penalty from the requirements. Would the judge still have had available the discretion to dismiss, even if not mandated under the new regime?
It would have, I think it would have come
If the
about,
judge had decided, well, you're still subject to these to these discovery requirements.
I think what would have had to have happened there would be a finding that the initial statement was illusory, i.e. the people, I think somewhat mirroring the current,
So that would be the only basis.
That's the way
Under
that
the
remedy
law at
would
the
come
time.
about, I think, yes.
Before this became effective, if the people didn't fulfill their discovery obligations, wasn't one remedy a judge could impose, forget the new legislation, was dismissal of your case?
I mean, I think it, broadly speaking, would fall within the discretion of the judge. In my experience, though, I mean, I think that's coming about where
Hopefully
there's.
you don't have a lot of experience.
No, hey, I'm an appellate attorney, so I can
Appellate lawyer,
always
you
shift the
say it
blame.
that way,
But it's where there was such a significant failing. You know, we declare ready, but we've really.
There were
you
a
know,
wide range of options available.
There were. It was.
Under the new statutory regime, when the people made their 30-30 motion that they made here, was it within the judge's discretion to provide an opportunity to, if the judge said, yes, it's after January 1st, you have to be in compliance, you're not in compliance, I'm giving you 10 days to do it, or was there, in your view, no option, no discretion on the part of the court other than to dismiss pursuant to 30-30?
I think given the extensions that have been built into the law, the judge could have allowed the people time to comply or correct some sort of oversight or error, just as we do now with supplemental certificates, if that is the scenario that the case is in. So sure, I think the court could have given the people some leeway without resorting to a finding that their prior statement was invalid.
Well, given what you said before about the stenographers, there might have been that argument that you're short-staffed for that purpose, for the grand jury minutes, and perhaps that's an exceptional circumstance, and you need more time to be able to put resources to that because of the budget issue.
Sure, I mean, again, I mean, this is, I don't want to speak anecdotally because obviously I don't really have anything in the record to support this, but I think it could be accepted. I don't think it's really a disputed statement to say that district attorneys' offices were going to be hard-pressed to comply with this.
Yes.
Even now, even with all the lead time, just because of the demands that it requires, but,
Fair enough.
that we are subject to it, so I recognize that.
Thank you.
Thank you.